Dude, let's talk about Mitt Romney. It's something we've been meaning to do all week. Let's jump right in, dude.
Dude, you're obsessed with Mitt Romney.
There's a pretty funny story in the Washington Post that they found the binders full of women. Someone reported that it's like 2 white 3-ring binders that contain over 200 cover letters and resumes with some handwritten notes. These are the binders full of women, the famous binders full of women that Mitt Romney referred to in one of the October debates against Barack Obama in 2012. So this is like big news. This is like real archaeology. This is a piece of the fabric of American political culture that has been unearthed.
Do you think it's going to go in a museum somewhere someday?
I actually think it should.
I think it should as well.
Hey, AJ, before we go on any further, do you think after the fact you could splice in the audio of Romney answering that question?
Governor Romney, pay equity for women.
Thank you, and important topic, and one which I learned a great deal about, particularly as I was serving as governor of my state, because I had the chance to pull together a cabinet, and all the applicants seemed to be men. And I went to my staff and I said, how come all the people for these jobs are all men? They said, well, these are the people that have the qualifications. And I said, well, gosh, can't we find some women that are also qualified? And so we took a concerted effort to go out and find women who had backgrounds that could be qualified to become members of our cabinet. I went to a number of women's groups and said, can you help us find folks? And they brought us whole binders full of women.
Can you have some fade-in music? Like we're fondly remembering?
I'm the tiredest I've ever been because I just went to a South Asian wedding.
Is that a yes to my question?
It's something, that's for sure. Okay, so...
Okay, back to Mitt.
There's an idea that Romney didn't come to office with a whole bunch of women that he knew that were qualified to serve. And so he went to remedy this problem. And the fact that he didn't come in there with everything, with tons and tons of women ready to serve or having identified them already, made it. You guys made it seem like that meant he wasn't qualified or that he wasn't concerned with issues related to women. And I think it's the exact opposite, right? It's that when he was given an opportunity to do something about it, he actually did something about it. And that's the type of thing that I think we should celebrate, not ridicule.
Ruchit, can I ask you a question?
Yeah.
So how is his answer responsive to the topic of equal pay?
I think what he's talking about is, I think pay equity is more than just about pay equity. It's about general equality in the workplace and advancement opportunities for women.
So Mitt Romney's full answer, and the part you're leaving out, the part that was completely tone deaf, was he said, really, this is about the economy. And if the economy gets good, women will have more bargaining power in the labor force. So
where's that?
To be clear.
Where's the quote?
We're going to have employers in the new economy, in the economy I'm going to bring to play, that are going to be so anxious to get good workers, they're going to be anxious to hire women. In the last 4 years, women have lost 580,000 jobs. That's the net of what's happened in the last 4 years. We're still down 580,000 jobs. I mentioned 3.5 million women more now in poverty than 4 years ago. What we can do to help young women and women of all ages is to have a strong economy, so strong that employers are looking to find good employees and bringing them into their workforce and adapting to a flexible work schedule that gives women the opportunities that they would otherwise not be able to afford.
His answer is, I'm nice to women. Some of my best friends are women. And also, if the economy gets good, that's all we need for women's lives to get better. Compare that with Obama's answers to the same question, right? So the question is, in what ways do you intend to rectify inequalities in the workplace? And Obama says, that's a great question. He talks about his experience with his being raised by a single mother. And then he talks about actual concrete policy gains that women have made in his administration.
The first bill I signed was something called the Lilly Ledbetter Bill. And this is named after this amazing woman who had been doing the same job as a man for years, found out that she was getting paid less, and the Supreme Court said that she couldn't bring suit because she should have found out about it earlier. She had no way of finding out about it. So we fixed that. And that's an example of the kind of advocacy that we need, because women are increasingly the breadwinners in the family.
And then he goes on to talk about other concrete policy gains. He talks about policies like making college education more affordable that benefit families. And
that's good for men and women, AJ. But
the point I'm getting at is that Obama had actual policies there. He had a thoughtful answer where he talked about actual things that he had done to improve the life of families and, in particular, pay equity for women. And then Romney says, some of my best friends are women. I have binders full of some of these women that I've been nice to in my life. He was governor of a state for 4 years. He ran a big private equity firm for however long. And the best answer he can give is, I treat women on my staff nicely and the economy might get good. And you can see how, in the context of this totally tone-deaf answer, the binders full of women comment takes off. And here's the reason I wanted to give that background. John Dickerson has a theory for why particular stories take off. Why are some narratives more interesting than other narratives? And basically, stories that tie into an existing narrative about a candidate are much more likely to capture the national attention, and they're much more likely to have legs and stay in the news cycle. And so here you have a candidate who is this sort of gangly, out of touch, patrician sort of, I mean, he just sort of seems like he's everybody's boss. Everybody who's ever hated their boss has sort of hated a guy who's sort of like Romney. And here he is trying to lead a party that is anti-choice and has mounted opposition to things like the Violence Against Women Act, and has mounted opposition to Planned Parenthood. And here's a guy who he's starting on the back foot. He's starting in a position where there is a negative narrative based on his personal background and based on the political party he wants to lead. And he comes out, and the best thing he can say about pay equity for women is that he has binders full of some of his friends who are women. And you can see how that's a totally inadequate answer.
Romney's coming at this with good faith. And I think you may disagree with him, but he's being unfairly attacked despite the fact that he came at it with good faith. And this is like a serious problem in our politics, I think, is you have someone like Romney that has done some of the right things, but not all of the right things that you would like him to have done. And so as a result, you ridicule him instead of saying, hey, these are the things that are wrong with your policies. And that's kind of precisely what happened to him after the binders full of women comment, is he got ridiculed in the liberal press by the liberal media, and people didn't look to say, hey, where was this guy coming from? What had he actually done in his life? Like, does it not mean anything that his state was ranked number 1 in terms of women in senior leadership positions? You'd think that was actually action. You'd think that was actually substantive. I mean, this isn't just some of my best friends are women. This is like putting your money where your mouth is in terms of who you choose to be on your leadership team.
Other than that, what else has he done for women?
Well, I mean, I guess I would say that I just don't know what else he's done for women. I mean, I'll be honest with you, but
well, might that be a problem with the answer he gave?
So you guys are focusing, I guess I'm not talking about the problem with the answer that he gave. I'm talking about the fact that he was ridiculed when it was clear that he was coming at it from a good place.
Shouldn't people be ridiculed for giving bad answers?
No, I don't think they should. I don't think they should be ridiculed just for being a little inarticulate, which was Romney's major.
Well, hold on. Was he inarticulate, or was he not actually responsive to the question?
No, I think he was inarticulate. If he hadn't said the binders full of women thing, this would have been this wouldn't have been something that ever got highlighted.
Rich, I think your general proclamation that we shouldn't ridicule people that are generally good or that are coming from a good place. I think that's something that everyone can generally agree upon, right? Do you think that Mitt Romney was coming from a good place? Like, what concrete policy advanced by Mitt Romney as a candidate for the governor or a candidate for the president of the United States would indicate that to you?
Well, I think it would be some of his economic and regulatory policies. Like, I think just because you guys don't like them doesn't mean that they're invalid. And I think that's the problem. You know what I mean?
Let's move on to something that's happened in the last 4 years. I wanted to make this like very quick, but I don't know that we actually got anything useful out of it. But I want to talk about voting rights. We've been
This is what I
recording-
mean, AJ. Like you didn't get agreement out of it. That doesn't mean there wasn't anything useful out of it. Just because you didn't like the result of it.
God, I'm gonna have to edit this crap. We've been recording for 27 minutes. So, voting rights? Do people have voting rights? Is this America?
Meh.
Voting rights are good.
So maybe it'd be helpful to give some background as to why we're suddenly talking about voting rights.
Yeah. Well, so basically there are like different forms of government, but the one that we have is called a republic. Other people would call it a representative democracy.
Can you go further back?
Okay. So think about it this way. Imagine the 100 Years' War. Now, what if I told you it lasted longer than 100 years?
I'd be okay with that.
Sounds like the past, man.
Okay. So, the Voting Rights Act is an act of the United States Congress. Huh?
Yeah.
That sounds right.
Well, I guess specifically, the Texas passed this voter ID law, and it's been in the news most recently because a Texas district court held that this voter ID law was discriminatory, was passed with a discriminatory intent, and so the court struck it down, and it's probably going back up to the Fifth Circuit. So I guess that's the most recent news thing that came out.
So, guys, I think like something that might be useful is talking about kind of why voter ID laws are not okay. And let me kind of start with that. With the I'm not arguing that there should be voter ID laws, but I think if you're a listener, you might think to yourself, because this is an argument I heard often. Listen, you need an ID to go rent a library book. Why shouldn't you need an ID to vote? So if there's a listener that's thinking that, what's your thought on that?
So what are the requirements to vote under the Texas voter ID law?
So there's a limited set of identification that you can have under the Texas voter ID law. One, it can be a driver's license, what's called an election identification certificate, or a personal identification card issued by the DPS, U.S. military ID with photograph, a citizenship certificate with a photograph, a U.S. passport, or a license to carry handgun issued by the DPS. And all of these forms of identification can be expired, but not more than 60 days. It's one of the so Texas has one of the most restrictive voter ID laws, according to these court opinions in any real state out there, because other states allow ID from others, out of state ID if you've moved here and you haven't had a chance to update your ID, that sort of thing. As well as other sort of identifications like college ID, for example. You can use your college ID in many states as a form of identification.
So, Tom, kind of going back philosophically for a moment, why are voter ID requirements not okay? And how do they sort of discriminate against people, right? Because that kind of goes to the heart of this matter. Because, again, I think a person listening might think it makes total sense. You need, you can't rent a hotel room without an ID. You can't borrow a library book without an ID. Why should you be able to vote without an ID? And maybe that's the wrong framing of the question, but I think it's helpful to think about, how does this law actually impact people?
No. And I agree with you, Ruchit. Like, I think that I've heard that argument quite a bit. Well, if I have to have an ID to get on a plane, why do I have to have an ID or why shouldn't I have to have an ID to vote? Or if I have to have an ID to rent a hotel, why shouldn't I have an ID to vote? And that's a common argument. And what I would say to that, is you are not everyone. And what I mean by that is you need to put yourself out of your own shoes and into the shoes of someone who maybe doesn't ever get on a plane, or maybe doesn't ever go and rent a hotel room, And I think part of the reason why there are case after case in the U.S. courts that are striking down these voter ID laws is because there's a significant portion of our population that that isn't privileged enough to do those things, because those are totally a privilege to do. It's a privilege to be able to travel across the country in 4 hours, right? it's a privilege to be able to check into a hotel and, sleep where you in a place that you're not renting or owning, right? So there is a significant chunk of our population that doesn't have these IDs, right? And when the courts, the courts aren't going through these voter ID laws and just saying, well, they're not being superficial about it. They're really getting into the nitty gritty of it, and they're looking, okay, well, if the Texas, for example, has this election identification certificate, right? And it was supposed to be this fix for people who haven't had or don't have IDs, right? Driver's licenses, for example. But in order to get that, you need to get a certified birth certificate, right? So that's like another hurdle. So you're a person without a car, right? Because you don't have a driver's license, right? And you need to go drive to wherever it is to get a birth certificate first before you can go to DPS and wait in line to get an election identification certificate, right? And before, when this law was initially passed, it would actually cost you money to get that birth certificate, that certified birth certificate, so you can get this free election identification certificate, right? So these are the sort of the nitty-gritty issues these courts are parsing through in determining whether or not these voter ID laws are or are not constitutional. And there are multiple, constitutional violations that these courts have found, right? 14th and 15th, whether they were passed with a racially discriminatory purpose and with a racially discriminatory effect. 1st and 14th, substantial burden on the right to vote. 14th and 24th, the voter ID laws are an unconstitutional poll tax.
Yeah. So I think this is I really like without I like what you said there, which is that you kind of have to start with the supposition that there are a lot of people that are not like you.
Yeah.
That's a hard supposition to start with, but I think it's the right one.
Why would someone want to adopt a law that makes it harder for people who are not like them to vote?
So, these laws were actually written by ALEC. What does ALEC stand for again? It's like the
American Legislative Exchange Council, something like that.
American Legislative Exchange Council. That's the good one. That's like really grabs the imagination.
Does someone want to give the history of that organization real quick?
Yeah, I'll do it. So this is going from memory. I don't know that I'm going to get this 100% right, but basically my understanding is that they're a political organization, and what they do is they draft model legislation, and they go from state house to state house, and they say, "Oh, you should think about adopting this bill." So for example, and they're extremely conservative. I think the 2011 Texas sonogram bill, the anti-choice bill, was like an ALEC model legislation that had been moving through some state houses in multiple jurisdictions. But they're basically a legislative advocacy group, in short. Does that sound about right?
Yeah, but I think they're affiliated with one party over the other, right?
Well, they're very conservative.
They're very and I think they would admit that. I mean, they're extremely conservative, and I think they're funded by the Koch brothers, but who isn't? Except us. We're the only people that don't receive Koch brother funding, which is really a travesty when you think about it, because here I am defending Mitt Romney, damn it.
I don't think we have enough listeners to start antagonizing any of our potential listeners, no matter if they are David or Trent and Charles Koch or not. I'm just saying, I think we should become like a conservative podcast. Maybe we should even try like being anti-Semitic or something.
I've got some great conspiracy theories.
Okay, so let's get back to voter ID. So ALEC sponsored this model legislation throughout the country. Wisconsin adopted something similar. Indiana adopted something similar.
Going back for just a second, I think it's also helpful to people that don't know a lot about these laws to say, hey, was this like a huge problem? Like, was there voter ID fraud just everywhere?
No, that's the short answer. In fact, the Texas court actually found that the voter ID law, this is an interesting fact, the voter ID law resulted in 2 convictions out of the 20 million votes cast under the voter ID law, right? So that is literally a 1 in a million chance of preventing voter fraud.
But there's a chance.
Well, if you listen to this district court in Texas, the reason why this law was passed was to discriminate against minorities.
How did it discriminate against minorities?
Prevent them from voting.
So are there no majorities, as in like white folks, that don't have voter ID? Or that don't have the IDs that are, put in this law?
Well, so I don't think it's like a per se rule, right? Like it's not, this only affects minorities, or this does not ever affect a white person, right? And I rarely think it's applied or thought of as that way, but it's looking at, okay, what was the purpose in passing this law? That literally that's the test. What was the purpose in passing this law, and what was the effect of passing this law, right? And it doesn't have to be the only purpose, right? The discriminatory purpose can be one of other purposes, right? And it doesn't have to be the only effect either, right? And it doesn't have to be, right, like the 100% strict effect of passing this law, if that makes any sense. It can be, the substantial effect in essence.
So what did the judge actually, I guess, so what's the legal standard by which this case was decided? And maybe it'd be helpful to kind of provide a little bit of background on what's happened in the last 3 or 4 years with the Voting Rights Act, if we want to do that.
Sure. Well, that the Voting Rights Act of 1965 was passed in response to certain states in the country that were passing laws to prevent certain types of individuals from voting. I don't know how specific of a history you want in that. But recently the Supreme Court struck down part of the Voting Rights Act, specifically the pre-clearance part. Basically, the Voting Rights Act said, look, you states with a history of doing bad things to minorities have to pre-clear any changes that would really affect your the ability of individuals to vote, right? And they had to pre-clear it with the Department of Justice. Basically, what the Supreme Court held was, well, that's kind of an old law. We don't really need that anymore, and struck that part down. I'm probably glossing over it in a significant portion.
Well, I think that's enough summary for our purposes. I guess the other thing you should say is that case was Shelby County, and we'll give a link to that. But basically,
it will appear in some notes, which will not. Yeah,
it'll be in the show notes.
Oh shit, AJ. Okay, I was trying studiously to avoid the term show notes.
I'm so bored right now. Okay, so I guess I don't know. So if you wanted to give the postage stamp version of this Texas case, what was so scandalous? What did the court look to determine that the legislators had a racially discriminatory intent in adopting the voter ID law? What was sort of, if you had to give, say, the top 2 or 3 pieces of evidence that the court relied on, what have you got?
Well, I think it's looking at the purpose, looking at what sort of things were done, and the sort of how the tool that they're using to solve the problem that they say exists doesn't actually solve that problem, right? So it's not any one thing; it's a bunch of things combined together that reaches the conclusion that it has a discriminatory purpose, right? So for example, it did not allow forms of ID that other states allowed. That would have been super easy to let, and wouldn't have had any adverse consequences on the purported purpose of preventing fraud.
Are you familiar with the recent North Carolina gerrymandering opinion?
You can tell us about it.
So I don't want to get too deep into it because it's sort of I mean, the short story really is the whole thing. But basically, there was a recent court opinion on some North Carolina legislative districts. So gerrymandering is a concept of drawing your legislative districts in a way that particularly disadvantages certain types of voters. And oh shoot, hold on, let me look this up because I think I just talked about gerrymandering and it's not a gerrymandering case. I have to cut all of this. Voting rights, decisions.
AJ, maybe we can just go back to talking about Mitt Romney while you're looking that up.
Oh my God, no. Okay. So the oh my God. Okay, Tom, I have a very important question.
What?
Are you familiar with the Are you familiar with the North Carolina voting rights case that came out in the last year?
I am actually.
Okay, so let's. Oh God, I have to edit this. Okay, so the basically there's like a huge smoking gun. Like the legislature specifically commissioned a study about what were the voting patterns of Black people, and then they passed laws that were specifically targeted to limiting those.
No, come on, seriously, they did this?
No, okay, yeah. Here's like one of the smoking guns. There are a lot of smoking guns, but this is pretty good. Quote: is there any way to get a breakdown of the 2008 voter turnout by race, parenthetical, white and Black, and type of vote, parenthetical, early and election day? A staffer for the state's Republican-controlled legislature asked in 2012. Quote, is there no category for Hispanic voter? A GOP lawmaker asked in March 2013 after requesting a range of data, including how many voters cast ballots. Yeah, these are like written emails. They were like, so they got their like, they got they commissioned like a couple studies about what in particular helped get what voting device tools were used in particular by Black voters to vote. So like souls to polls, where the churches, Black churches traditionally would bus voters to the polls during early voting, right? So you like go to church, and waiting outside a church, there'd be a bus to take you to the polls. It's called souls to polls. So they eliminated early voting on Sunday, which Texas also did, by the way, for the same reason. So the Fourth Circuit was like, look, like, usually it's like difficult to divine the legislative intent in some of these voting cases, but like not in this one. This one, it's not difficult.
I mean, so is it the response of these Republican legislatures? Look, we're not racist. We're just trying to keep ourselves in power. And the best way to do that is to prevent Democratic votes. And it just so happens that, Black people vote for Democrats more than they do us.
So, it's interesting that you say that because, to me, it's definitely not, and I don't think it is to anybody, but it is sort of an interesting flip side of the political gerrymandering argument where people are saying, listen, it has nothing to do with race. We're just trying to keep ourselves in power. So we're drawing districts that have, that are designed in a certain way to make sure we maximize, the number of seats that are given to our party. So it's an interesting flip side, I guess.
There's okay, after we finish, I actually really want to talk about the Wisconsin case on that topic, but I don't want to do that yet. Let's finish talking about Texas. But that exact point, like, these are not racist, these are partisan voting measures, is like a really interesting question.
Well, how do you separate that out, right? Like,
well, I think that's really interesting because I think is it the mention of race where you separate that out? Is it the finding of Democratic voters versus Republican voters? What if you're just sort of blind? What if you're blind to race? Does that make political gerrymandering okay? I mean, I know these are kind of the key crux, key issues here.
Yeah. Let me ask you another question, right? Is that argument any different than saying, look, I'm not trying to be racist. I just think we should enforce our drug laws as much as we can possibly enforce.
I guess it depends on sort of what are the drug laws that you are trying to enforce, right?
So do we, is there anything else to be said on voter ID? Like, do you want to talk about partisan gerrymandering?
Yeah, I think...
I say we move to partisan gerrymandering, yeah.
Okay, so gerrymandering is the idea of drawing your legislative districts in a way to disadvantage certain voters, right? So you can imagine if you have a state with, say, 5 Democrats and 5 Republicans, and let's say there are 6 Democrats and 5 Republicans, and you need to draw 3 districts. One thing you could do is have, just split everybody up evenly, right? Like each district has the same number of Democrats and the same number of Republicans. Another thing you could do is put all of the Democrats in one district, and the remaining 2 districts can have some very small number of Democrats and mostly just Republicans, right? And so in one scenario, you would have 3 Democratic districts, and in the other scenario, you would have 2 Republican and 1 Democratic district, right? So you can see how the way you draw your districts results in a minority of voters ending up controlling a larger number of districts. So,
or you could have, so AJ, to be fair, you could also have a slight majority of voters, or let's say you have 55% majority, you could end up controlling 2/3. So it's not necessarily as pernicious as, you have 40% of the voters, but you figured out a way to control, 2/3 of the districts.
Well, I think both of those are equally pernicious. So one of the things that's been interesting is that the Supreme Court has been fairly skeptical of racial gerrymanders. So gerrymanders that are designed to reduce the voting power of minority communities are fairly suspect. But the Supreme Court has actually said that they're much less concerned with partisan gerrymanders. So if the legislator's intent really genuinely appears to be race neutral, and it really is just about which communities are Democratic and which communities are Republican, the Supreme Court has been much less critical of those sorts of schemes. In fact, the Supreme Court has said you can take the partisan makeup of districts into account when districting, but such classifications are not totally exempt from equal protection scrutiny. So there's an explicit grant of power to use partisan makeup of districts when districting, and that case was Gaffney v. Cummings in 1973. Last year, the Wisconsin District Court, a 3-judge panel, put out an opinion on whether the Wisconsin legislative districts were constitutional. And so background in Wisconsin. Wisconsin before 2010 had never had legislatively adopted state assembly districts, state assembly and state senate districts. So in 1980, you do a census every 10 years, and you do your districting every time there's a census. You can do districting between censuses, but it's like really suspect. Like, you shouldn't need one until you know where your new population is. So you do one after every census. So in 1980, the census happened. Wisconsin needed new maps. They had a Democratic legislature and a Republican governor. They couldn't get new maps. A federal district court ended up having to draft the maps. In 1990, same thing happened again. They had to use the federal district court to get new maps. In 2000, the same thing happened again, and they had to use a federal district court to get new maps. In 2010, for the first time in over 40 years, one party controlled the legislature and the governor. And the Republicans in power in Wisconsin adopted a massively partisan mapping scheme. And the interesting thing is they left a huge paper trail. In a document that was called, quote, summary.xlsx. So it was just an Excel file that the staffers in the GOP were emailing around. They created a written analysis of how partisan the potential maps were. For the map that they actually selected, it turns out that the Republican statewide vote share could fall to 48%, and they would still have a pretty substantial majority in the state assembly. By contrast, Democrats would need 54% of the statewide vote to capture a simple majority of assembly seats. So this is not just, the sort of somewhat partisan districting situation that the Supreme Court had talked about in Gaffney. This was like a serious and nakedly partisan gerrymander. The holding of the court was that you can't do this. Like, this is a bridge too far. The dissent is totally bizarre, and I want to read a quote from the dissent, because this is totally nuts. Like, the idea that people that aren't worried about gerrymandering is sort of weird. So here's a quote. The plaintiffs are evidently of the view that the Republicans, having achieved the once-in-a-lifetime feat of controlling both branches of the legislature and the governorship during a redistricting year, should have used that unique opportunity not for self-advantage, but instead to draw a map that was less favorable to them than even the court-drawn plan that governed the previous decade. Ironically, even if the Republicans had said to themselves, quote, "Let's stick with a plan like the one drawn by the federal courts, it helps us enough already," the plaintiffs would still take umbrage at the resulting map. This is crazy, right? I mean, this is like a federal judge saying, "To the victor go the spoils." It's just crazy. The one other thing that I think is worth thinking about, and then, we can talk about it some more, is that the present state of our democracy is that race is a pretty good proxy for how you're going to vote. That minority voters are overwhelmingly Democratic, and white voters are not quite so overwhelmingly Republican, but odds are much stronger that your given white voter is going to vote Republican. And so partisan gerrymanders have racial effects. And if the Supreme Court is going to give a pass to partisan gerrymanders when there's no obvious racial animus, it means that state legislatures would have a free hand to have racial discrimination in their voting schemes.
So AJ, what's your view on when partisan gerrymandering is okay? Is it ever okay?
Well, so here's the deal. I think that you do need to take partisanship into account when drawing districts. If you want districts that are fair, then when talking about racial gerrymanders, one of the terms that people use is that you want minority candidates to be able to select candidates of their choice, in which case you need to understand who are the candidates of choice for these minority communities. And so you do need to take partisanship into account. You do need to take demographics into account, and you need to do, a lot of what 538 does. 538 creates demographic models of elections. And the demographic models are really interesting because you don't actually need a lot of public opinion polling of the current election to sort of be able to predict how the election ought to go. You can say, well, we've analyzed exit polls from the last 3 elections, and we've seen that in exit poll responses, people with these sort of demographic characteristics, income level, race, gender, urban or you live in a rural or an urban community, et cetera, et cetera. These sort of demographic links can actually predict future elections, even if you don't do public opinion polling for the candidates in a given election. And so I think that when you're drawing districts, if you're trying to draw fair districts, if you're trying to allow minorities to elect candidates of their choice and things like that, then you sort of do need to take partisanship into account. But the problem is when you purposefully create districts where 48% of the vote can capture almost 2/3 of the assembly seats.
Well, even more basic than that, I think, the idea of gerrymandering erodes our democracy, right? If you have, because, and you really need to only look at a map of the districts in the central, for basically the hill country, right? Like Austin, how Austin is sort of split up into so many.
Tom, yeah? I think you need to look at the districts for the American heartland, which is synonymous with Austin.
Yeah.
The heartland, aka Austin, has 5 districts. And is split. I mean, I think that's, where I live is so I live in East Austin, and there's East Austin, and then the district snakes up all the way to Fort Worth.
Yeah, it's pretty bad.
Well, so Lloyd Doggett represents a chunk of Austin and a chunk of San Antonio.
Yeah, he's got that the I-35 corridor.
He goes all the way to the border, right? So I think it's also helpful to just go back. The point of these districts, or the point of kind of having districts to begin with, is to say, listen, this group of people has common interests. And part of that commonality of interest is determined geographically, right? And it makes sense, right? The people that live in Austin have a commonality of interest on things like water, on electricity, on, all kinds of issues that are going to be different than the people of San Antonio. So it makes sense for the people of Austin to have their own congressional district, or maybe even 2 or 3 congressional districts. But maybe it doesn't make a whole lot of sense for one part of Austin, which is on the east side, to then be in the exact same district as Fort Worth, right?
Mm.
And so I guess going back, though, can we have a district drawing process that's done by a state legislature that is not going to politically gerrymander? Like, it just seems, to me, it seems like that's impossible.
I mean, states do it, right? I mean, it's possible. So,
well, a lot of states actually have these independent commissions that draw the districts. So I think like California has an independent commission that draws districts.
In California, what's to prevent anyone from packing those commissions?
California Citizens Redistricting Commission. So it's wedrawthelines.ca. That's pretty cool. Interesting. The 14-member commission consists of 5 Democrats, 5 Republicans, and 4 commissioners from neither party.
I sort of disagree with you that single-member districts have all of these tremendous advantages. Right? Like,
do you mean like single city districts, or
no, single-member districts? So like a district where all of the members of the district, like all of the citizens of the district, elect a single member to the legislature. Right? Like there are all sorts of countries that don't have single-member districts.
That's true.
Like what's the alternative?
I mean, there are a lot of alternatives. The most common alternative is proportional representation. So countries like Israel and Germany have a proportional representation system where people just vote for their party, and the party runs a slate of candidates. So, I mean, one example of how proportional representation could work is the party says, okay, there are 100 seats in the legislature. Here's our list of 100 people in ranked order. So if we win 10% of the votes and get 10% of the seats, then you go with the top 10 people on our list. So that people don't represent particular districts. You just have members of the legislature who are members of the party.
And there's a lot of different ways to even do proportional representation, but that's definitely like the simplest and, maybe not the most elegant way, but definitely the simplest way. So what would happen is if Texas is, let's say, 55% Republican and 45% Democrat, then that would mean that there are 55, in this theoretical example, 55 seats would go to the Republicans. The parties would choose which 55 actual human beings go in those seats, and 45 would go to the Democrats, and then the Democrats would choose those 45 actual humans.
I mean, other countries do this. Justin Trudeau actually told, when he was elected Prime Minister of Canada, as part of the campaign, he said that he was going to try to reform Canada's voting system, because Canada right now has a Westminster-style parliament with single-member districts. And he said that he thought proportional representation would be more fair.
That would mean the breakdown of a 2-party system, right?
Yeah.
Oh, yeah,
that's
definitely.
But that's like a feature, not a bug, right? So there's something called Van de Vanter's law, which says that single-member districts tend towards 2-party rule, and that proportional representation would tend towards having a more diverse set of political parties.
That would require a constitutional amendment, right?
Oh, yeah, for sure.
But so I guess what should people take away? Like, someone listening to this, has heard about what's going on in North Carolina and Wisconsin and Texas. Like, what's the takeaway? Like,
let me give a takeaway, and then you guys can give one too. I think the takeaway is you should think very carefully about what people do, or what basically legislators do and what states do to regulate who can vote and under what circumstances they can vote. That's sort of the first thing, is what are the real necessary things for people to vote? And should that be whether it's a voter ID or is it something else? And then how easy should voting be? And so should we do anything that makes it harder to vote, or should we make voting as easy as humanly possible, right? So that's the kind of the first thing. And the second thing is there's something going on under the hood of the democracy as it relates to how the actual districts are drawn. And that ends up having partisan effects for sure, but has other effects in terms of whether people are actually getting their voice heard through the democratic process, through the voting process. So anyway, those would be my takeaways.
Do you think there's the sort of do you think that the Shelby County case where the Voting Rights Act was the preclearance requirement for the Voting Rights Act was struck down? Do you think that there have been legislators who have been dying to discriminate against certain voters either on partisan or racial grounds, and that Shelby County opened the floodgates? Or do you think that this is something that reflects how partisan our country has gotten? Do you think that, I guess, do you think that even that racial gerrymanders are really about race, or do you think they're about partisanship, or do you think it's both?
So let me answer your Shelby County question first, right? So I think Shelby County was very poorly decided. I think that there should be preclearance requirements, and I'm not the only one. When Congress did its study on the reauthorization of the Voting Rights Act, they had I think 25,000 pages of evidence in the record. And I distinctly remember reading Scalia's opinion in Shelby County when he said basically that wasn't enough. So, you talk about kind of judicial deference to Congress. There probably wasn't a more developed record on the continued existence of discrimination in voting rights than that. So I think Shelby County was definitely a step in the wrong direction. Kind of on your question as to, is this just a sign of the times or of how partisan we are? I think on something like voter ID, I don't think that's a partisan issue. I think that's denying people the right to vote. And I don't think you can even dress it up in sort of partisan niceties, if you will, of, all we're trying to do is make sure that, that we continue to win elections. I think that's straight up denying people the right to vote. On some of the other issues, I think it's a little bit harder on redistricting, and probably without independent commissions. I don't know how you really avoid it.
On voter ID, I wonder how privacy-minded conservatives would address that issue. You know what I mean? That the government is mandating you to have an ID in order for you to exercise a constitutional right. Has anyone made any hay about that? Right, because the government, that's exactly what that law is telling you to do, right? You have to have this ID that only the government can provide you in order to vote, in order to change your governmental institutions.
I mean, yeah, right. It does make the government a gatekeeper for an access to power that you don't really tend to associate with how we think about American democracy.
But I think at the end of the day, the problem with redistricting on a partisan level, whether it has a discriminatory or non-discriminatory purpose or impact on a racial level, is that I don't think it's healthy for our democracy when you're supposed to be voting, in a geographic sense, right? Like you're supposed to have, the geography is supposed to decide your sort of common interests as a people, right, or a group of voters, and that geography is sort of cut and spliced and gerrymandered.
Yeah, I totally agree.
Seems bad.
Guys, should we go to the sidebar?
I do have a Supreme Court case if you want to hear.
Oh, I would love to hear a Supreme Court case.
So this case is called Town of Chester v. LaRoe Estates Incorporated. And the issue is whether interveners must have standing to intervene in a lawsuit. So traditionally you think of lawsuits as plaintiff versus defendant. I sue Ruchit or Ruchit sues AJ, right? But in a situation where Ruchit sues AJ, the federal rules allow for certain classes of individuals that are necessary to the resolution of the lawsuit. It's not the exact language of the rule, but it's close enough for our purposes to intervene in that lawsuit. So if there's something about, my presence that would make the lawsuit more difficult to resolve, then I would have a right to intervene as a matter of law, right? And so the issue here is if you have a right to intervene under Federal Rule of Civil Procedure 24A2, when you have an interest in the lawsuit and deciding the lawsuit would hurt that interest, right? Must you also have a personal stake in the outcome of the lawsuit, which is also known as standing. the issue is basically more or less whether standing is something more or different or less than the requirements to intervene under Rule 24. And this is a case where this individual, Steve Sherman, wanted to develop about 400 acres of land in Chester, New York, as a residential subdivision. Chester decides to pass some pesky zoning regulations that get in the way of the development. In the meantime, Sherman contracts to sell this land to LaRoe, pending approval of that land development. LaRoe advances Sherman $2.5 million. Basically, Sherman's negotiation with Chester falls through, and Sherman sues Chester. LaRoe moves to intervene as a matter of right. Sherman's bank, which had a mortgage interest on the property, begins foreclosing and forecloses on the land. So there's no more land for LaRoe to get an interest in, right? And so when LaRoe tries to intervene in this lawsuit between Sherman and the city of Chester, the district court says, well, you lack standing because, in order to assert a takings claim, you have to actually have an interest in that property. And since there's no more property for you to have an interest in, you lack standing, and therefore you can't intervene. District court ruled that's what the district court ruled. And the Second Circuit reversed, saying the interveners as a right do not need to establish standing. So that's the case in a nutshell.
Man.
It's not as sexy as our other cases, but,
I mean, no, I think it is. I think it's pretty interesting. So for our listeners, the doctrine of standing really has to do with who has access to the courthouse, right? And if you haven't, the theory is, if you haven't been, Tom, correct me where I'm wrong here, or AJ as well, of course. If you haven't been injured, then you don't have a right to bring a lawsuit. And so some of the most...
Yeah, so
go ahead.
So another way to think about this, right, is let's say, Ruchit, you're suing AJ, right? And I want to intervene. But if I don't have standing, what that in effect is saying, I wouldn't have the right to sue AJ on my own, But for some reason, I would have the right to intervene in this lawsuit between you and AJ. And that's the question, right? Like, does Rule 24, the rule that gives me the right to intervene in this lawsuit between you and AJ, allow me that gives the court the power to hear my intervention claims, right? If I'm intervening, I can make the same claims, right, that I might be able to make in an independent lawsuit against AJ, maybe.
So I think the other issue is that, as I remember, standing is a constitutional issue in the sense that the court cannot hear cases. So the court basically does not have jurisdiction to hear your case if you do not have standing, if you cannot claim that you have been injured by the activity of the defendant, or in this case, by one of the other two parties.
Yeah. It's this idea that, look, courts aren't just going to sit around and issue advisory opinions. That's not the role of the court. The role of the court is much more limited. The court is only there for when there's an actual dispute between two people who have an interest in the outcome of that dispute.
And I think some of the standing, the sort of cases on standing have talked about, I mean, the ones that are my least favorite have to do with whether a public interest group has standing to challenge some activity by the government. So does an environment...
The organizational standing.
The organizational standing. So, I mean, I'm of the belief that organizations that represent the public interest or some large group of members do have been injured, but Supreme Court disagrees with me. But given that this is a case about courtroom access and the direction in which the Roberts Court has gone, and really just, I think, conservative majority courts have gone in general,
what cases are you talking about?
I'm talking about
because it's my
Lujan. I'm talking about Lujan. Isn't it Lujan?
Yeah, Lujan v. Defenders of the Wildlife.
Do I have that case wrong?
Yeah, you have the case wrong, right? But it's not. I didn't think Lujan was a step too far, right? The basic facts of Lujan were these individuals wanted to sue. Because some funding was cut off, if I recall. Let me just search it real quick. So these environmental organizations lack standing to challenge regulations jointly issued by the Secretaries of Interior and Commerce regarding a geographic area to which a particular section of the Endangered Species Act arises.
Dude, I think AJ's trying to talk, but we can't hear him. AJ, I can't hear you, dude, at all. We've lost AJ.
Oh, man.
He's typing, though. AJ, do you want to type out everything that you think?
Can you hear me?
AJ.
Okay. Here's why I think this case is so interesting, right? Because the Article 3 controversy stuff. Basically there's a constitutional provision that says the courts in the United States can hear cases in controversy, and that's been interpreted to say that there has to be a controversy that is adjudicated between two individuals. What Tom and Ruchit were talking about, right? The thing about this case that's so interesting is that whether or not an intervener actually has an interest that will be adjudicated in the proceeding or can be adjudicated in the proceeding is ostensibly not implicated by the case in controversy clause, right? Because there already is a case in controversy between the two parties that are the plaintiff and the defendant.
Well, the other thing is the other argument would be, look, Rule 24 already has a standard by which you have to judge whether they have an interest, right? Because Rule 24 says you have a right to intervene only when you have an interest in the lawsuit, and deciding the lawsuit would without you would hurt that interest, right? That's, roughly what it says. It's that. Well, does that cover standing?
This is super interesting, right? So I don't know. I think this is like a sort of useful case to use to talk to listeners about what standing is, what intervention is, why do third parties participate in proceedings. I'm sure a lot of people don't even know that random people can just parachute into your proceeding and start participating. I know, right?
We should do that more often, by the way. Like, we don't parachute into proceedings ever, and I think that's a mistake. And maybe we can.
Well, we've always talked about filing amicus briefs. Maybe we can file an amicus brief, as a podcast.
So, on behalf of our listeners, I like that, Tom.
Oh, we could have organizational standing.
Exactly.
Yeah. Well, yeah, and that's what I was saying. That's what I was saying earlier, is that, look, could there be a situation where in that lawsuit between Ruchit and AJ that I couldn't intervene as a right, that I could intervene as a right, but I wouldn't be able to sue AJ independently? That's essentially what this question is asking.
So I guess I might be misunderstanding the question somewhat. Is the question whether Rule 24 is constitutional, or is the question whether this case meets Rule 24?
No.
What's the question? Deep down?
No, neither of those are the question. The question is whether interveners as a right must have standing to intervene in the lawsuit.
So do they need Article 3 standing requirements?
Yes. Yeah.
The answer to that, maybe we can go to the predictions phase of it, but to me the answer there should be obviously, or maybe not should be, but I think will be obviously yes.
And by what vote count?
I think it'll be 9-0.
9-0 for Chester?
Yeah.
Chester is the party that is asserting that interveners must have a right to, or must have standing in order to intervene in the lawsuit.
Yeah, I think it's going to be 9-0.
AJ?
I think Rule 24, right? Rule 24 says that you have a right to intervene if you claim an interest relating to the property or transaction that is the subject of the action and is so situated that disposing of the action may, as a practical matter, impair or impede the movement's ability to protect its interest. So you can imagine that applying to all sorts of interveners that don't actually have standing to sue, right? Like, you could say that there's some sort of secure transaction. So I want to buy widgets for Ruchit, and I put my car up for collateral. And so now Ruchit has a property interest, a secured interest in my car. And you can imagine other members of my family, right? Like, and then I die, and there's like a probate proceeding that affects my car, And a probate is when you die and you dispose of your estate, right? So you could say that like your heirs and your descendants have the right to bring probate cases. Ruchit can't probate my will, right? He's just like a creditor on my car, but he could definitely participate in a probate proceeding to make sure that my car doesn't get distributed to like my children or something, right? Like, I mean, there are all of these ways that people intervene without necessarily being able to bring the action in the first place, right? So they don't necessarily have standing. I mean, I guess they technically have Article 3 standing, but not statutory standing. I think when you phrase the question so absolutely right, that people need to have Article 3 standing, I think it's much easier to say that the standards for intervention are looser than the standards for bringing a case in the first place. So, I mean, in a strict answer to that question, the answer is probably no. You probably don't need Article 3 standing to participate in a proceeding.
And that is the question presented, right? The question presented at the Supreme Court is whether interveners participating in a lawsuit as of right under Federal Rule of Civil Procedure 24A must have Article 3 standing, as 3 circuits have held, or whether Article 3 is satisfied so long as there is a valid case in controversy between the named parties, as 7 circuits have held. So there's a circuit split as well.
I'm going to say 5-4 with an expansive view of intervener standing.
So, LaRoe?
Wow. That's bold. That's bold, AJ.
Okay. 5-4 LaRoe.
You think this court is going to increase access to the courtroom or to the courthouse?
So Ruchit, I mean, going back to that topic, right? Like so this is a conversation we were having while AJ was muted. Basically, what is standing, right? And I think the case that Ruchit was referring to was Lujan v. Defenders of the Wildlife, and this was basically a case that is sort of explains our modern understanding of what Article 3 standing is for the purposes of some organizations, right, or some people. And this was a case in which the American this Defenders of Wildlife sued these basically the government because of some regulations that affected particular species in particular regions of the country, and sort of the often quoted language from this case is about how, look, this individual doesn't have any sort of interest in the lawsuit that is not concrete or particular. Rather, it's just a conjecture or hypothetical one. But if only they had just, made some effort to go and see these endangered animals, right? Whether it was like had an intent to buy a plane ticket to travel to see these animals, then they would have standing, right? Like that's always sort of been the line this case, and at least in my mind, is drawn, is that it's a very low bar to have standing, but you have to have something particular, right? Some concrete action that demonstrates that standing, right? Whether in the case of these Defenders of the Wildlife, you buy a ticket to go see these endangered animals. Ruchit, is your understanding different?
I don't know. I mean, I think what you're saying sounds accurate.
I think my point is much narrower than that, though, right? I mean, if you are interpreting the question in the strictest sense, which maybe I shouldn't be, right? But the question is like, can you be an intervener if you don't have Article 3 standing?
Sure. And I was just using that to jump off to standing in general, because we had that earlier conversation about, whether the court was narrowing what you needed in order to have in order to bring a lawsuit to begin with. And I guess I just don't see that, I don't see that the court is narrowing. In fact, I almost feel like the most recent line of cases have broadened the scope of standing for a lot of these organizations.
Yeah. All right, Tom, what's your prediction?
My prediction is 9-0 Chester. I think the court is going to find you're going to have standing in order to intervene in a lawsuit.
Interesting. Ruchit?
Oh yeah, 9-0 Chester. Even though I've heard all of your good arguments, I still think the court is going to find that. I think it's going to be like 10-page opinion or something too, where it's just going to be like, of course, you have to have standing, and that in fact the intervener rule presumes that.
Cool. Sidebars?
I got a sidebar.
What's your sidebar?
It's very good. My sidebar is very good. My sidebar
Dude,
is...
nothing will be better than last time's sidebar. That crazy dude.
Weird Twitter. Oh, I have follow-up from Weird Twitter.
Yeah?
So last week's, AJ, your sidebar was about Weird Twitter and all these weird people on Weird Twitter, right?
Yeah.
Since then, I've read this article published called The Oral History of Something Awful, which was basically an internet forum that started in the very late 90s and went all the way through the late 2000s, right?
I mean, it still exists.
Yeah, it still exists, but like it was at its height in the early 2000s, basically. And I one of the interesting things I learned in this article was a lot of the people that AJ were referring to on Weird Twitter were originally members and writers of this forum called Something Awful.
Yeah. Okay, so my sidebar this week is a YouTube video. It's very good. It's a very good YouTube video. Actually, so it's in the Google Doc. Tom and Ruchit, you may want to click on this while I'm talking.
Okay.
So
I've clicked on it.
Okay. So this is a YouTube account called Miss Yeah or Miss Yi. I'm sort of not totally sure how to pronounce it. Miss Yeha. And she, I honestly cannot tell how real this is. So she is like a white collar worker in China, and she has this desk job. She is working in sort of this open floor plan. So her desk is her, there's no like barriers between her and like dozens of other workers all sitting at their computers and doing stuff. And the premise of this YouTube channel is that she like scurries around her office and takes random pieces of like computer equipment, or there's one episode where she uses like a space heater and she cooks lunch sitting at her desk while people around her are trying to get work done. So in episode 7 of Miss Yeah, she makes a Chinese hamburger by disassembling her desktop computer case, and she like breaks up a wooden flower planter in the office and like lights the planter on fire and puts the side of the computer case on top of it to make a hot surface. And then she's sitting in the office, like sitting at her desk, mixing a batter.
How does she still have a job?
Yeah, I mean, I cannot figure out like
This can't be real.
this can't be real, right?
It can't be real, dude.
Are you watching this? Are you watching her
it
take her
can't-
computer apart?
Yeah, I'm watching this right now. Like, this can't be real. Here's my arguments for why it can't be real.
'Cause it's happening.
Camera work is too good.
Well, yeah, of course. But
right? Like, this is like what is this? Like a documentary on this lady? It can't be a documentary.
So here's my point. Like, I can't figure out if this is like really a place of business, or do they just have like dozens of extras sitting at computers doing nothing? Like, does she actually work here and this is like promotional for her company? The video doesn't have any like dialogue, and almost all of the YouTube comments are in Mandarin. And so I can't figure out.
I gotta say, I do appreciate her cleaning out the computer case before cooking on it.
Have you gotten to where she mixes the batter for the hamburger bun?
No, I have not.
This whole thing is crazy, right?
Yeah, they're just sitting there like they've got
Do you think we can get her to plug our podcast? Because she seems to have a lot of people.
So I understand that like this person is like, this is not clearly something that is like commonplace in Chinese offices. But the thing I don't understand is like, is this a real place of business? Is this like a TV studio? Like, what is happening? Like, why is this happening? She's eating what she claims is a Chinese hamburger, and I had to look up on YouTube what a Chinese hamburger is, and it actually looks like really good. It looks like pretty tasty. As far as I can tell, it's like halfway between a breakfast taco and a steam bun.
She's mixing the dough.
Isn't this nuts?
What is she doing?
Right? She like lit a fire inside her desktop computer case.
This is like MacGyver shit going on right here.
Isn't this totally nuts? Okay. That's my. Everyone should watch the video. I'm totally.
Oh, these are like crepes. She's making crepes.
She's making crepes, but inside an office. There's another one where she like
Ooh.
makes her boss a birthday cake at her desk and then brings it to him.
This looks delicious.
Oh, there's a new Steam Bun episode that was uploaded a couple days ago. I haven't seen it yet. She's gonna make Steam Bun at her desk.
So
I'm gonna watch that tonight.
All right. My sidebar.
Yeah.
is the Internet History Podcast, specifically episodes 137 and 138, The History of Google. And it's just a really interesting look at the, like the creation of Google by Larry and Sergey, and how it formed together as a computer, and specifically he spends a large portion of the time talking about how they came about inventing search, or not search, but PageRank, which was their algorithm for search. And what's so cool about that is that they were not, they didn't, go looking to revolutionize search. Instead, they were just thinking about these academic problems while doing their thesis work, and they just kind of stumbled upon it from their history. They both, Sergey and Larry, were Montessori kids, and their parents were academics. And, apparently part of being a Montessori kid is that you're not assigned any homework, or you're not told to do any one thing. It's like whatever you want to do in order to learn will facilitate it, right? And so that's sort of how they grew up. And, there was one particular example of how when they were thinking about how to organize these search results, they were thinking, well, in academia, when you write a paper, your paper is sort of lives or dies by the number of citations other people give to you, right? Like, because the more cited a paper is, the more important that paper is generally thought of in academia. And they just brought this idea over to the web, right? The more times individuals link to a web page, presumably that gives an indicator of how important that web page is, or how relevant that web page may be to a particular issue, and then and that algorithm evolved from there. I just thought it was an interesting podcast on one of the biggest companies in the world right now.
Dude, I should listen to that podcast.
It's on my to-do list. I should tell you something important. A lot of the time when you were talking about that, I've been watching Miss Yam make a steam bun.
Me too.
Tom, I don't know how you were able to keep your focus while that was happening.
I don't know, those Chinese hamburgers look delicious.
She's using a drill.
Dude, this is definitely fake. There's no way this is like her actual office.
Yeah, but are people like getting work done? That's what I can't figure out.
I'm sure they are. Oh,
I mean,
man,
their job is to help her film the show. So.
I think if I were working in that office, I would be most upset by the fact that she's not sharing.
There's one episode where she shares her noodles with a coworker.
Oh, she does?
Yeah. She takes the water cooler apart, and she makes hot pot in the water cooler, and then she and her coworker make some hot pot and eat it together.
Sharing is caring, dude.
Rich, what you got?
Man,
I mean, not only can she cook, but she apparently has enough knowledge of computers in order to take it apart and put it back together. It's pretty impressive,
dude. I feel like my my sidebar is not as good as y'all's. I think maybe I won't even do a sidebar.
Rich,
no. What's your
Rich,
sidebar?
You should pick a different Miss Ya video and make that your sidebar.
Okay, let's do it. The steam bun video. That's my sidebar. And AJ, if you can find the taking apart the water cooler one, that could be my sidebar extra. My extra sidebar.
Okay.
Dude, that could be your sidebar next week.
Dude, I'm going to give away 2 sidebars this week.
Okay. I want to watch the steam bun video. Should we call it?
Well, Ruchit doesn't have a sidebar.
Oh, dude, I just told you my
his sidebar is the steam bun video.
Yeah, dude.
Okay. All right. Fine. Yeah, we've been going 2 hours. Maybe we should
call it a day. Yeah. Our poor listeners. Dude, I can't believe you guys didn't let me tell my story about the Wyoming coal miner.
I can believe that.
Yeah. That's a stupid story.
I have to tell you something.
What's up, dude?
I'm the tiredest I've ever been.
Dude, you need to... I think you need to work on your Indian wedding stamina. So, AJ, how much weight do you think you gained at this wedding?
Like 5 pounds.
Okay, that's good. That means you had a good time.
I ate so much food.
Yeah. So, AJ, I think another thing our listeners would probably like is to learn about your experience with Pawn.
Oh, okay. Actually, this is going to be good. So, at the wedding this weekend, I was introduced to something called pan. It is. I haven't looked up the wiki article for this, so I'm going entirely off of what some uncles told me at this South Asian wedding. Okay, so it's like a banana leaf that they stuffed with some like paste and spices. And the first couple nights, the pan was like soaked in like tamarind juice or something sweet like that, like rose water and tamarind or something. And so it's this like, I'd say it's about like, it's the size of one of those like paper footballs you used to play with in class. And you stick it inside your cheek, like between your cheek and your gum, and you just kind of suck on it. And so at first it's like really sweet, and then it's like really minty. It tastes extremely good.
Oh, dude, you were definitely chewing tobacco, by the way.
I don't think so. They told me that.
I think so, because like the pan that I always eat, you're supposed to actually eat. You don't like kind of put it in a ball and you're like, in your cheek and like just kind of suck on it. That's definitely like tobacco, dude.
According to Wikipedia, it's chewed for its stimulant and psychoactive effects. Did you see anything that wasn't real, AJ?
It's hard to tell. It's hard to tell what was real and what wasn't real. I was eating a lot of food. So like, what they told me is that usually they make it with tobacco leaves, but they didn't put any like stimulants or drugs in these. Although often it has like betel nuts in it or something like that. Is that a thing? A betel nut?
I've never heard of that.
Okay. Well, I don't know. There's some sort of nut in there that like can get you high sometimes. But they told me that the pan that we had was not psychoactive. But then, and this is the dopest part, on the night of the actual wedding, they had like a make your own pan station, so you could get like leaves, and there was 3 or 4 assortments of like spices. One of them was like really heavy on the anise, and I skipped that. There was one that was like really minty.
AJ, I think you mean anise.
No, I don't. I do have a niece.
Yeah,
her name's Rachel.
Anyway, so that was I had pan ice cream a month ago at an Indian wedding, and that was definitely the best ice cream I'd ever had.
Wait. So this white paste, which no one explained to me what it was. I like started to make my pan, and this auntie was like, "Don't put too much; it will burn you. Like, this will burn your mouth if you put too much white stuff in." And I put the very tiniest amount of white stuff in, and she was like, "That's too much." But it was fine. I didn't burn myself. I didn't wrap my pan very well, and then the spices sort of ended up in my mouth instead of inside the leaf.
The Wikipedia pictures of the health effects of pan are pretty gnarly, dude.
Oh, these people have some really messed up teeth.
That's what I said.
Oh no, but these people are having pan that's full of tobacco. There wasn't any tobacco in my pan.
How do you know?
Because I like rolled my own pan
on day 3.